For the record, please. For the record.
Mark Sherman, Your Honor. Law Office is Mark Sherman.
Ryan O'Neill with the Law Office of Mark Sherman on behalf of Ms. Hogan.
Good afternoon, counselors, and Attorney Harding, good afternoon.
Good afternoon, Your Honor. Your Honor, it's the state's understanding that Ms. Hogan does intend to post bond today. In light of that, the state's asking for some conditions regarding her release, if I may be heard on those.
You may just one moment. I always like to note for the record that there was some discussion in chambers with counsel for the defendant, counsel representing the alleged victim as well as the state. We did go through some things. We'll put those on the record. I'll hear argument if there is argument. The court will make a decision on what conditions, noting that the intention is that someone is going to be posting bond for Ms. Hogan. Please proceed.
Yes, Your Honor, it is the state's understanding that the defendant does intend to post bond today, and in light of that, the state is asking for conditions of release to include IPS and a GPS bracelet, that she'd be on home confinement aside from any medical emergencies or court appearances that are required for her to be in person on. State's asking that any of those visits to court be verified and pre-approved through probation, asking for the protective orders that I provided to Madam Clerk, that those be issued for all 5 individuals, and that the defendant continue to comply with DCF as well.
Understood. Attorney Sherman.
Yes, Judge. Your Honor, with respect to some of the protective orders before you, some of those minors aren't directly affiliated with or related to any of the allegations in this case. For that, we understand an abundance of caution the court's issuing this now. However, we do want to make it known that we'll be revisiting these issues once we have information from DCF to bring to Your Honor to perhaps modify those orders at the appropriate time. As to IPS and GPS, Your Honor, as long as my client is permitted to, she needs to live out of state in Massachusetts temporarily. I know that's not a typical IPS allowed with IPS, but I think in this case, the courts have allowed defendants to live out of state with certain exceptions. One of your orders, Your Honor, the arraignment was to comply with DCF. She will be, and for that reason, she's not permitted to live in her current home with her parents. So we're now asking if she can go live with paternal grandparents so that she can comply with the DCF order to allow certain minors to be at the home. So she wants to comply with all of Your Honor's orders. I believe she'll be in a safe, supportive environment in Massachusetts. No objection to the state's restrictions on her movement for now. We can revisit those as time goes on. I would ask that she be permitted to attend legal matters with us. If we need to, perhaps we can come to Your Honor if that's necessary. We can certainly do virtual appointments. But she will be in Massachusetts. That's our proposal to Your Honor. I know we've cleared that address with bail, and she can do virtual or in-person meetings with probation at the closest probation office of the court or bail's choice.
Thank you. Before we go into the actual conditions, just with regard to the protective orders, of course, if there are change of circumstances or other information for the court to consider, Attorney Sherman and others are very familiar with how the court approaches protective orders. Certainly consider those at the appropriate time. With regard to the issue of home confinement at, you said paternal or maternal grandparents?
Paternal.
Paternal grandparents. I believe the state may wish to be heard on that because it is a little bit of a divergence, but we'd be crafting this in a way to be substantively compliant with all IPS, GPS requirements. Attorney Harding.
Thank you, Your Honor. The state does object to the defendant living out of state. IPS, by the supervision by probation, can only occur in the fullest extent if she's in the state of Connecticut. The probation officer is a Connecticut probation officer, and all the requirements of IPS cannot be met if the defendant is out of state. While saying that, Your Honor, the state does appreciate that the children are everyone's greatest concern at this point, and this address does allow the compliance with DCF conditions. However, the fact that IPS cannot be addressed to the fullest extent outside the state, this state does object to her moving outside the state of Connecticut.
Certainly, and the court did review administratively some of the elements of IPS and to see what would be different with a potential out-of-state placement. The most substantive one that the court can identify, and I'll certainly hear from Attorney Sherman or from the state, as well as bail commissioner, if necessary, is that it is the home visit by an officer of the court going to that home, or officer of probation, bail, going and checking that. Otherwise, I believe substantively, everything else with IPS, GPS can be implemented, and the court will go over this, should it grant the IPS, GPS at an out-of-state location, how that would be addressed substantively with regard to check-ins, as well as address the issue of leaving for any emergency medical appointments, for court or other legal matters. There also is, I do have the motion to preserve evidence, we'll address that in a moment. There is another issue that was brought, I know, to the attention of the court, as well as attention of counsel in the state just a short time ago, regarding the mental health 5 level and potential transport to hospital.
Yes, Your Honor, it's the state's understanding that when the defendant was evaluated at York, that there are concerns and that there is an order that she be evaluated by Danbury Hospital, by a hospital upon release, and that obviously here would be Danbury Hospital, yes. So, in discussion with Your Honor and counsel, it is the state's understanding that the bracelet can be issued and then the defendant can be evaluated. The state's remaining concern is, Your Honor, that although we were assured that the bracelet would remain while the defendant is at the hospital, the state's concern is that there have been situations where bracelets have been removed for safety reasons at hospitals. And in light of that, the state is asking Your Honor to, that if Your Honor intends to release the defendant on a bracelet today, that we have a 1-day continuance. In the event that the bracelet is cut off, the defendant, by the hospital, the defendant's obligation would be through her attorney to call the bail commissioner, alert them to the fact that the bracelet was cut off, and that she report to the court on the next business day to reissue the bracelet.
And just, I want to be clear on the record for that. I understand what Attorney Harding, what you're saying with regard to releasing the defendant on an electronic monitoring bracelet. The issue here is the defendant intends to postpone. The court is not changing the bond to effectuate release here. These are conditions that will be placed because the court had ordered at the last date that bond is to be posted courtside for the purpose of this court to issue conditions of release, and that's what the court is considering. With regard to the bracelet, the issue here, and we did discuss this briefly in chambers, that if for some medical reason the monitoring bracelet is removed by the clinical authorities at the hospital, that bracelet would have to be reinstalled or reattached tomorrow at this courthouse. You would have to return. We'll set the next date and we'll do the conditions of release. The other issue here is that once these conditions of release based on the defendant posting bond are implemented, and if the out-of-state home confinement is granted, upon release from hospital, if that's in 3 hours or it's in 12 hours, the defendant has to go directly to that place of home confinement. No deviations, no recreational trips. And I don't mean to be sort of flippant about it, but not even to buy a bag of potato chips. It is directly to that address which has been provided to bail commissioner and probation, I believe. Is that correct?
Yes, Judge.
Okay. Before we impose the conditions, as well as go through the protective orders, Attorney Sherman, Attorney Harding did put on the record with regard to the state's concern about the out-of-state placement, as well as the issues of hospitalization, evaluation, and the bracelet.
Sure. No objection to any procedures with respect to the bracelet being removed, Judge. We do not anticipate that bracelet will need to be removed. We anticipate she will be going to, if granted, will be going to her paternal grandparents this evening. Your Honor, and as far as making a little bit of an exception for IPS, I do think in light of the court's order of compliance with DCF and my client's willingness to work with the court and the state on those recommendations, it does provide some basis to make this exception. And Judge, the bracelet will be monitored in real time. If there's ever a question, I believe the court's orders will allow the monitoring probation officer or bail commissioner to give her a call and make sure virtually she's in the house she's supposed to be. So I think we can all kind of take a lot of comfort in that, and we understand there will be severe consequences if she does not comply.
And to that point, I did confirm with the bail commissioner that a video check-in could be done at the discretion of the Office of Adult Probation, and they could geolocate the defendant at that time to ensure that she is at the location, not only during that check-in, but at any time with regard to the monitoring electronic bracelet, and if it is cut, a signal is sent, and bail is aware of that. I just want to confirm that with Ms. Trudell. Is that accurate?
Yes, Your Honor.
Thank you.
The only remaining issue, I apologize, Your Honor,
Yes.
that we had addressed in chambers and that I failed to address in front of Your Honor. It's my understanding that Attorney Sherman is in receipt of the defendant's passport. The state is asking that the passport be turned into the clerk's office before the bracelet is put on today.
And we did discuss that in chambers. The other issue is, and I'm not going to ask some questions directly of your client, Attorney Sherman, but we did discuss this issue briefly, is does your client have any other passports?
No, Judge, I just canvassed my client. This is her only passport. May I approach the matter?
Yes, please approach. Record reflect that Attorney Sherman has provided the passport. Is it a valid passport at this time, not expired?
I didn't check the date, Judge, but I believe Madam Clerk has it.
Yes, Your Honor, I do have it in front of me. It is valid until 2032.
Thank you. The only other person or counsel did not ask identify for the record, and I'm not sure if counsel for the victim wishes to be heard on anything or just identify for the record for purposes of the transcript.
Yes, Your Honor. Good afternoon.
The alleged victim.
Attorney Jill O'Connor on behalf of the victim. And I don't have anything that I'd like to address the court.
And I will note Attorney O'Connor was present in chambers during the discussions as well. Before the court does go through, and there is quite a list of things that we will go through before the protective orders as well as the motion to preserve evidence. Anything further with regard to the conditions?
Nothing in terms of condition, Your Honor, no.
No, Your Honor.
Attorney Sherman, there would be a 10% cash bond. Is that your understanding?
Yes, Judge, I believe I have to formally request. I'm just asking that the court orders that it may be paid with 10% cash versus a surety bond. It actually is more than my client would have to pay if they were to pay a bondsman. And again, I'm not asking for a reduction in bond.
Bond remains set, $1 million, 10% cash will be acceptable, being posted with the court. The conditions will be as follows. If bond is posted, conditions are IPS with GPS. That is, the bracelet is to be affixed or fitted today here at the courthouse. The issue here, the carve-out, the court will grant the home confinement to be at the location of Massachusetts, the address of which has been provided to bail commissioner. The bail commissioner will monitor that from whichever is the most appropriate or efficient from Connecticut. That will include weekly check-ins. That is at the discretion of probation, whether those will be in person by Ms. Hogan to check in directly with that office or virtually, noting the previous discussion regarding geolocation and video check-in. That addresses the two first conditions. With regard to the home confinement, the carve-outs are for in-person required court appearances. The reason I want to be very clear on that is there may be some parallel civil or administrative matters in connection with this case that may not require in-person appearance. Therefore, the carve-out is for required in-person appearance, as well as any emergency medical treatment or any legal visits that require in-person appearance. Those legal visits for the time being are to be virtual. If there are to be in-person appearance, legally, you need to provide that information, Attorney Sherman, to probation for them to verify the need for that. All of these carve-outs are to be verified, and the appearance or leaving of the home needs to be pre-approved by probation. Passport has been surrendered. In addition to that, the condition is to make no new applications for a replacement passport. You're also to comply with any requirements of the Department of Children and Families. With regard to the mental health level 5 as determined at York or by DOC, after the affixing of the IPS, GPS, the bracelet, as required based on the evaluation of the level 5, if you are transported to Danbury Hospital, you're to comply with all clinical requirements at Danbury Hospital. You are not to remove the bracelet. If a clinician does remove the bracelet or other person at Danbury Hospital, based on their determination that it needs to be moved for a medical or clinical reason, You are to contact, or your attorney to contact bail in order to report that. You would need to report to this court tomorrow, 10/10, to have a new bracelet affixed. If you are released to whenever you are released from Danbury Hospital, the defendant is to be transported directly to, with no deviations, recreational trips, or otherwise, in the most direct route to the address in Massachusetts as provided to probation. If the bracelet is not removed and the defendant is released and transported as is required as a condition of release, that next court date tomorrow, 10/10, would be an administrative date. We can then waive appearance and set a next date for substantive purposes. Is that acceptable both to the state and Attorney Sherman?
Yes, Your Honor.
Yes, Judge.
Are there anything with regard to the conditions that I might have missed?
No, Your Honor.
Nothing from the state, Your Honor.
Madam
no.
Clerk, you have all the conditions.
Yes, Your Honor.
We'll now address the issue of the protective orders. There are 5 protective orders. They are all full no-contact protective orders. This is a single file. The reason I bring that up is I will be canvassing the defendant on all of them at the same time. They are all the exact same provisions, full no contact.
Your Honor, just to clarify, it's full no contact with a 100-yard stay away, correct?
Just want to make sure it's on each one. It is.
Okay,
Full no
thank you.
contact with 100-yard stay away. For the purposes of the protective orders, Ms. Hogan, without saying the person's names or relationships to you, you know the person with the first name, first initial T, last name, initial L.
Yes.
You know the person with the first name, first initial L, last name, initial H.
Yes.
You know the person with the first name, first initial E, last name, initial H.
Yes.
You know the person with the first name, first initial R, last name, initial L.
Yes.
And you know the person with the first name, first initial R, last name, initial L, space H.
Yes.
Or refer to those persons as the protected persons, yourself as a respondent. The terms of each order are as follows. That you are to surrender or transfer all firearms and ammunition out of your control and possession. You're not to assault, threaten, abuse, harass, follow, interfere with, or stalk the protected persons. You are to stay away from the home of the protected persons and wherever those persons may reside. You are not to contact the protected persons in any manner, including written, electronic, or telephonic communications. You are not to contact their homes, the place of work as may be applicable, or other persons with whom your contact would likely cause annoyance or alarm to those protected persons. And you are to stay 100 yards away from each of those protected persons. You understand those requirements?
Yes, I
You also understand that once these orders are issued, they are court orders. They cannot be modified by yourself or other persons, but only by further order of the court.
do. Yes.
And you also understand for a violation of protective order that a person could be charged with a felony and face up to 10 years in prison. And finally, do you understand a violation of protective order may be considered a violation of a person's bail and their conditions of release. For such a violation, a person's bail could be increased and release could be revoked. Just allow me one moment to complete the orders. Want them all at once?
That's fine.
Your Honor, I did just speak to Attorney Sherman. Out of an abundance of caution, the state is going to ask for the addresses of the protected parties to be an exclusionary zone on the GPS bracelet.
Okay, of each of the protected
Yes,
parties?
Your Honor.
Okay, Attorney Sherman?
That's fine, Judge.
So that's additional condition, and Mr. Dell, is that able to be effectuated through GPS?
Yes, Your Honor.
Okay, so that is so noted as a condition that to be an exclusionary zone for the address. Is there a foot or meter radius, or is it just the property itself? Does probation determine some
We can-
sort of proximity,
We can go by the, what's ordered on the protective order.
the 100 yards?
Correct.
And Your Honor, I just know that I believe bail is considering Danielson to be a reporting office. One of those addresses might be up that way, so if bail could just take note of that, make sure they don't overlap.
Absolutely.
Thank you.
So noted, thank you very much. Okay, should be fine, and then just make sure. Madam Clerk is going to collate those and will provide copies of protective order to Ms. Hogan. just as a housekeeping matter, we did discuss this in chambers, that should Ms. Hogan, should the bracelet be removed, or either way, Ms. Hogan not present herself to this court on a date when she is supposed to present herself, or remove the bracelet, not clinicians removing it, but Ms. Hogan remove the bracelet, could be subject to a significant bond increase and other charges.
Judge,
Understand that now?
she intends on being fully compliant with court
I
orders.
understand. Have the orders been provided?
Yes,
The record
Judge.
reflect all protective orders have been provided to counsel for the defendant. And 10/10, which is tomorrow's next date, will waive appearance if unnecessary based on the bracelet. I'll go to count to the state first. Is there anything further for the record?
Just administratively, Your Honor, the state's asking that this matter be moved to Part A.
Yes. So ordered. Now move to Part A. Attorney Sherman. No, it's,
Your Honor,
Yes,
it's just the motion to preserve, and I think that would be it. And
the court has received a motion to preserve. We did discuss this briefly in chambers. There are 4 requests, I believe 1, 2, 3 are what the state is, what counsel is proceeding with, and not provision 4 on page 1 regarding the cell phone at this time.
correct, and to be clear, there's 5 proposed orders, there's one that goes on the next page. But Your Honor is correct, we are only asking the court to consider 1, 2, and 3, those are the only ones we are proceeding with. I think the grounds are specifically stated in the motion, and I'll turn it over to the state and address any needs that the court, or any questions that the court has.
And anything further, Attorney Sherman?
No, Judge.
Okay, Attorney Harding.
State has no objection to the motion, Your Honor. The state made state police aware that this motion would likely be granted, and they intended on preserving this anyway.
Thank you. One, 2, and 3 will be granted with regard to preservation. 4 and 5 denied at this time without prejudice.
That's Your Honor.
I just asked Attorney Sherman, I know that tomorrow is going to be an administrative date unless we need to come in light of the bracelet. I think that council and I agreed on December 2nd for an actual next court date.
That's fine, Judge.
So 12/2 would be the next date unless there's a reason for tomorrow. But it will be on the docket tomorrow. You can waive appearance if necessary and just put, and then 12/2 will be that date.
Thank you, Judge.
Anything further for the record?
No, thank you, Your Honor.
No, Your Honor, thank you.
Madam Clerk, are we all set?
Fish from